Good morning. It's raining, in case you couldn't tell. Let's talk about CPS, Child Protective Services. I think we can all agree that kids make mistakes, and that the mistakes kids make, generally speaking, shouldn't haunt them throughout their lives. I think you probably agree with that. Those CPS records should be sealed. They should not be accessible to the public. I definitely agree with that. I think we all can agree with that. If you don't agree with that, let me know. But and let me know why you don't agree with that. I'll expect a good argument from you. But I think generally speaking, we can all agree that any mistakes kids make in their youth should be sealed and be prevented from public dissemination. Now, with that kind of understanding in mind of CPS and how those documents should work, let's talk about Earl's little fireside chat about the state of his case. I have not watched the whole thing. I want to warn you on that. I was given 2 timestamps to watch, and I watched those 2 timestamps. And I'm confining my commentary to those 2 timestamps. I don't remember exactly what those 2 timestamps were, but they were where Earl was talking about some 30,000 documents that he received from the state that he wants to publish, and the state is fighting him, and they're filing all sorts of protective orders. And another statement that he made, that he has received from the state all of the past and ongoing special operations from the Fusion Center, and he wants to make those public, and he intends on publishing those, but again, the state is fighting him. Well, funnily enough, oddly enough, interestingly enough, the state doesn't have to fight him on publishing any of those documents, any of the 30,000 documents, or any documents that he may or may not have received from any Fusion Center or other law enforcement agency. It is written into Texas law, Texas Code of Criminal Procedure, Article 39.14, roughly thereabouts. Any documents or other tangible evidence that the state gives to the defendant, or technically it wouldn't give it to the defendant, it would allow the defendant to review it, but the state may give the attorney for the defendant an electronic copy of any photographs or reports or anything like that. Any of those documents, the defendant is prevented by that article, Article 39.14, I think it's subsection E, somewhere in there. The defendant is prevented from disseminating any of those documents or other materials to any third party. So Earl, whether he wanted to or not, whether the state raised its finger or not to prevent him from doing it, it would be illegal for him to do that. I don't know what the penalty for it is. I haven't looked into that, but he can't do it. The state doesn't have to bring a protective order to do it. Now, if you look at the docket, if you look at what has gone on so far in Earl's case, you can see that there is in fact a motion for a protective order, which was granted. And there is currently a motion to quash that appears to be outstanding. The judge has not ruled on it yet. And then there was a motion for an in-camera hearing. An in-camera hearing, in case you're not aware, is where the judge has a meeting with the parties. And by parties, I mean most likely the counsel for the defendant and the prosecutor. It's going to be just the judge, the counsel for the defendant, and the prosecutor. Maybe a court clerk or a court reporter are going to be present as well. But it's either going to be in the judge's chambers or it's going to be in court, but the court will be cleared. Now, the purpose for an in-camera hearing is typically to discuss sensitive data and how you're going to handle that sensitive data. And what I am suspecting is going on is that Earl, through his attorney, subpoenaed CPS records, presumably for the victim. Now, those CPS records are confidential, and since they are provided by the state, 39.14 would prevent Earl from publishing any of those documents. However, it may not prevent Earl from talking about the contents of those documents or even misrepresenting the contents of those documents. He could say, I have seen those documents and they state that the victim is a horrible, terrible slut who likes to sleep with 89 guys a night, 87 of which are her brothers, and 84 of which are ugly. He could say all sorts of terrible things. And so what I'm assuming is, and this is just an assumption, but the in-camera hearing and the motion for protective order was to prevent Earl from discussing to his YouTube audience the contents of those CPS documents. Because this is supposed to be taking place in court. He is not supposed to be disparaging the victim or to be making this into a public, a trial by the public, a public opinion trial. The question before the court is whether or not Earl sexually assaulted his daughter or his daughters. I'm not entirely sure if it's just going to be one daughter or all of them. Apparently it's just one daughter at this point, but we'll see how it goes. That's the question before the court. Not whether or not the victim did bad things as a child, whether she got caught shoplifting or whether she had a boyfriend too young, whether she got pregnant, whatever. It doesn't matter. What matters is Earl's conduct. Did Earl sexually assault his daughter? That's what's before the court. So I hope that makes everybody happy and it explains what's going on there, or at least gives a reasonable explanation for what I think's going on. There is a motion hearing in January, I believe, and unless I'm mistaken, and I may well be mistaken, but it appears that there has been no order on the motion to quash the CPS documents. What I am suspecting is that the judge had the in-camera hearing and he wants the attorneys, I'm guessing, to prepare memorandums saying why, for the defense, why they need that information, why they need to be able to present it in court, what they expect to accomplish with it, what law or other precedent supports their right or their ability to access that information and use it in court. And then the judge, I'm assuming, is going to want a similar memorandum from the prosecutor saying why that information shouldn't be made available, etc. And the state can, another possibility is the state does redact information. The state only has a requirement to turn over information that's relevant to either the prosecution or the defense for that particular matter. Probably it's also likely to lead to relevant information, I would guess. I'm not entirely sure on that. But the state may also have redacted too heavily for the defense's point of view the CPS records. They may have turned over not enough of the CPS records, and that might also be what the motion hearing is on, whether or not the state has given sufficient data. So anyway, I hope that helps. Hope everybody has a wonderful day. I hope this was informative. Thanks for watching. Have a great day.